And we're back.
And we're back.
So
Today's weather is hot as fuck.
yeah, people are complaining about the weather we got this weekend. They're getting it on the East Coast. Um, for those of you who weren't outside on Saturday and Sunday, it was blustery, I think is the word. So
So Sunday it did end up being worth canceling?
it's hard to tell because the wind's always worse out east.
Correct.
And I stayed inside for most of the day.
You didn't go
But
outside?
I did go outside a little bit, and it was very cold
Yeah.
with that wind going. So I think it was the right choice because, like we talked about on Saturday, when the weather is so bad that you can't hear somebody
Yeah.
talking, or people are thinking about their kneecaps freezing off, then they tend to stop listening, stop learning.
So
So
I get asked this a lot. And do you guys cancel for weather? And for me, it's always no. If you're a little bitch, you can't handle the cold. But there does come a point where weather becomes dangerous. And towards the end of the carving class, when nobody can hear what the fuck you're saying, even right here, like that
mm,
becomes a safety issue. That was my biggest thing. That shit was bad.
yeah, I was screaming into for that test your limits drill at the end. I'm face to face with the students in the class, and I'm just screaming. Do you understand what you're doing?
Yeah.
um, yeah. So great class on Saturday. Postponed the class on Sunday, and that postponement is going to May 2nd. So now, if you're like, dang, I couldn't have gone to the first one, but now if you're open on May 2nd, you can join us for that one. So
Yeah.
we're gonna have a special guest today, but before we do, let's pop the links. Donate, donate to the podcast. You're gonna get some information in this podcast. I don't think you can get anywhere else on a gun podcast.
No. No, I,
And
I think it's gonna be good. It encourage you guys to yell, ask the questions that you guys need to ask, say the things that you need to say, get that shit off your chest today. But yeah, we're gonna have I think a good conversation. It's Chris is his name. It's 97 out right now, 4:30 p.m. This guy lives in Arizona. And
beautiful.
beautiful. Um, but yeah, Chris, he's a Dr. Chris to you motherfuckers. Dr. Chris. He is going to talk about I would say he's probably one of the most versed humans about ERPOs here in the state of Colorado. Now, obviously, you and I, to say we disagree with the ERPOs is probably an understatement. Well, to say we disagree with the government is probably an
And just for
understatement.
anybody listening, ERPO is Extreme Risk Protection Orders, a red flag.
Yeah.
Uh, Edgar always assumes that you've known him his whole life and you know exactly what he's talking about. And I've known you for a long time, and half the time I don't know what you're talking about.
That's the problem with having a new toy.
Mhm.
And again, I've had it for a while. I just can't stop doing it.
There we
Yours
go,
does it
Joseph.
too,
Get it
right?
off your chest. Get off your chest. Red flaggers are stupid. Um, so the point of having Chris on is to talk about exactly what they are, how they work, and how they've been used in the state of Colorado.
Yep.
Chris is agnostic when it comes to firearms, at least as far as this discussion goes. As far as I understand, he's not going to be talking about the good and the bad. He's going to be talking about the how,
Yeah.
so that people are educated and informed on what these actually are, how often they get used, who do they get used by,
Correct.
um, that kind of stuff. So definitely share your feelings, but understand the point of the conversation is to educate, so that when anybody brings up ERPOs, you hopefully have some idea what you're talking about.
Yeah, one of the things that we see in the gun community a lot, and it sucks, is when humans that are against these laws say things that are hyperbolic. Is that the word?
Or
Hyperbolic?
even just flat out not true.
Correct. And we see this a lot with lobby groups, all the time. Like if everything is a gun registry, everything is woe is me, and the sky's falling, and these are bad laws. I'm not. Obviously, they are bad laws. We're not going to pretend like they're not bad laws, but we also have to be objective about how we look at the laws and the numbers and uh, all that shit. So
Yeah, kind of like to that point. I was listening to another gun podcast this week, and they were sharing their most controversial gun takes. Just humor, not humor, but like I guess like to pass the time. Oh,
yeah,
what do you think? Oh, 22 ILR for self defense. Oh, I think revolvers are actually great for women. Like controversial takes. And this one guy, he says his most controversial take is that he absolutely agrees with the statement that AR-15s are weapons of war. And his point of that was to say, um, if the Second Amendment is about defending your rights and you buy guns knowing, believing that at some point you may need to use them to defend your rights,
yeah,
why wouldn't you call that a weapon of war?
fair,
I mean, that is your intent. Um, and warfare is always conducted with the weapons you have. It's not conducted with the weapons that exist out in space.
correct.
So
Ask the Afghanis; they do fucking rocks. They'll fucking topple
yeah,
a whole government.
weapons of war are whatever is available to use to resist or to go on the offensive.
Yeah,
So, um, I mean, you could make the same argument that nukes aren't weapons of war because Iran is not using them for war, but could be because they don't have them. If they had them, they'd use them.
you,
That's a stupid analogy if you really take it to the to a logical conclusion.
this is what we argue all the time. Is you have to be careful on one, your own perception of the shit
Hmm.
that we say. And a lot of times we don't even agree with what we just said. Well, you just
Yeah.
seen it live. Isaac not agreeing with the fuck with what he just said.
Wait a minute. That was dumb. Shouldn't listen to that guy.
Um,
Uh,
at any
but yeah,
rate,
I mean, it's talking about firearms and ignoring their capacity to do harm because you're trying to win an argument. Oh, it's not full auto. It's not a weapon of war. Yeah, but if full autos were legal, you'd be arguing why you should be able to keep them.
correct,
It's
correct.
so we have to be as objective as we possibly can when we're arguing, and you have to know what you're talking about, and you have to be honest,
Yeah,
because a dishonest argument is never going to convince anybody.
correct.
Well, it's only going to convince the stupid people, probably the easily swayed people.
Easily swayed.
Um,
On that note, let's bring this human on, um, and
I feel like
allow
I should
him
have dressed up.
to introduce himself. Yeah, he dressed up. It looks like he's dressed up. Uh, you and I look like a bunch of fucking pigs. Remember, it's doctor to you.
Doctor.
It's doctor. So I'm gonna bring him on, and then you guys let him introduce himself. Oh, did it? Oh, there we go.
Hey,
Hello.
how's it going?
Hey, how's it going, man?
It is
Hey,
going
good,
well. Have
good
we
to see
met, Chris? I don't know if we've met.
No, we have not, but it's
Okay.
great to meet
I
you.
always feel like a stroke victim every time I like meet a new person because I honestly can never remember if I've met people or not. So I have to be that awkward person. Like, have we met before? So
No, no, I've heard your voice. I've not met you by face.
okay.
So, like, it's great to meet you this way. Otherwise,
And
so
and
and
icebreaker
yes, I
question.
did wear this to work, and I showered, and all that stuff. Like I did everything appropriate.
How do you pronounce your last name?
Kanaki, you say every letter.
Kanaki. Okay. All right. Just
You
like
actually say
knife.
the K.
Yeah.
You do say the K. No.
Yeah.
And appreciate y'all having me on. I now have easily the worst lighting and the worst sound of the three of us. So I
Oh, for
apologize.
sure. That's all right.
We're just tryhards. We're just like fakers, you know. We
For
have
sure.
nothing to bring other than lighting and sound.
I should have brought a cool green light to shine behind me.
Yeah, yeah.
Nah, the I'm about to take my mugshot look is always better when you have good information. Again, to Isaac's point, we're the weirdos that know nothing here. Um,
I severely doubt that.
yeah.
So on that note, why don't you introduce your background around your academic background, just you know the highlight sheet plus your background with the extreme risk protection orders and where you got to how you got there.
Yeah, no, sure. So again, appreciate coming on. I am an associate professor at the University of Colorado School of Medicine. I am the director of strategy also for the Firearm Injury Prevention Initiative at the University of Colorado School of Medicine. And you know, in that capacity and in the firearms related work that I've done, it's involved a lot of different things. So I'll get back to ERPOs in a second. But you know, I started off. So I'm a social worker by background, right? So like I have a master's in social work, I have a PhD in social work, I have my license for clinical practice. Like I used to do, like even while I was in graduate school, I was a person who operated a small employee assistance program where like part of what the deal was is that anybody who worked for one of our like contracting businesses or anybody who lives with them could come in and see me or any of my staff to just talk about like whatever was going on in their life that they wanted help with, right? And so that I brought that in when I finally like finished my PhD and I moved over to working at CU. And I was fortunate through some of the work that I was doing there in the cardiology space, which is still like where I kind of live. Like I'm an associate professor of cardiology, but I was fortunate to get hooked up with Dr. Emmy Betts, who Edgar knows at least. I don't know if you know Isaac, but does amazing work in firearm suicide prevention, and specifically like geared toward let's think about when we're talking about firearm injuries and deaths. Let's think about what we're doing with respect to suicide, knowing the statistics around that. And I was able to then, it was really kind of nice to be able to pull that sort of clinical experience that I'd had working with people, just sort of one to one, or as a couple or whatever else, into the world of academia. So a lot of the things that we spend our time on are things like pause to protect, right? Like what we're doing is we're trying to promote good communication from healthcare professionals and otherwise to people about safe storage, about thinking about how storage might look different if somebody in the home's in crisis, or if there's other things that are going on that might be a safety concern, and voluntary out of home storage. So like what the Armory Project does, what Pause to Protect does, creating systems of firearm businesses who will sort of participate and help sort of bring a service to the community around opportunities for safe storage. And as part of that, I got involved with helping to evaluate at the time. So this was like 2016, 2017, evaluating the new GVRO law in California. And I worked with a group there that was looking at sort of how that had been implemented and working at the time. And that was really fortunate for me because Colorado voted them in 3 years later. And I was sort of in a nice position to say, well, like I have a pretty good understanding of what happened in California, so we can replicate a lot of the science, at least that we were doing in California and Colorado, just to like see how it's working, who's using it, who's not, and under what circumstances they might be most effective. So that's how I got hooked into these various things, and how I come to you as like the ERPO guy, if you will.
So GVRO in California, is that gun violence restraining order?
Yeah, sorry, I'm throwing acronyms at you
No,
without
that's okay.
explaining them. No, in California, their version, in every state, their ERPOs are slightly different, right? But the California is one of them that has a different name for them, so they call them gun violence restraining orders.
Okay. And just for historical purposes, Colorado passed the ERPO law in 2019.
Yeah, the very good. No, the vote happened in November 2018. There was a year of implementation time in 2019, and then the first petitions were available January 1st, 2020.
Okay. All right. So it went into effect January 1. Okay.
Yeah.
All right. So I don't know, Edgar, if you have any place you want to start, but I was thinking if we could do just a quick summary of what the original law is and what it's where it's at now. Just what the, not the letter of the law, like reading the law, but just understand
Yeah.
kind of the fundamentals of how the law worked in 2020 and what changes have been made since then in our legislative sessions.
Yeah, no, absolutely. So, starting in 2020, and actually, I don't know if that was meant to be for Edgar or for me. Like, I'm for both.
You're
Yeah, no, I was just doing him a courtesy. I didn't really care what he had to say. So,
so there you go.
All right, no, I'm picking up on the dynamic here. All right, this is good. Like I said, I used to be a social worker. So when it was passed in 2020, there's a couple of things that make Colorado's situation, how ERPOs work, unique. So one of the things that varies state to state is the list of eligible petitioners, right? Like, so what kind of relationship to the person that you're filing it against do you have to have, right? And so in Colorado, who's been available since the start were law enforcement, right? So like police can file against somebody as long as they have contacted them in a professional capacity, and that's universal, that's available everywhere. And then in Colorado, the only other groups that were available in 2020 were basically like people who live with the person or who have had a romantic history with the person, right? So this is roommates, this is spouses, these are family members, right? So it could be parents, it could be kids, it could be brothers, sisters, and then co-parents, even if they haven't lived with the person for a long time, right? So like your roommate could file against you as long as you've lived in the same place within the last 6 months, and then co-parents could still in theory file against each other even if they've been separated for a long time, as long as they share a dependent together, so as long as they still have a kid together. What was added in 2023, so a couple of years went along, and the state legislature decided to add a few groups to the list of eligible petitioners, and this was a little bit more controversial, right? Because the groups that I was talking about before are pretty typical across states in the U.S. But who was added included medical and mental health professionals, right? So as long as you have had a relationship, a clinical relationship or a treatment relationship with the person you're filing against, again, in the last 6 months, or educators. And so this is either K-12 or higher education, as long as like that person has gone to that school or whatever. And then district attorneys. And so that's what's been added. Those are sort of the major fundamental changes that have been made in the last, 5.5 or 6 years now.
So I want to just clarify something because you said something that I didn't know was true. So I just want to clarify.
Yeah.
Law enforcement officers were part of the original group of people who could file.
Yes, correct.
Okay. Because in my mind, the historical record was that they couldn't, and then the Club Q shooting happened, and there was a lot of focus on the fact that law enforcement had contact with that person and knew that they were some kind of a risk because of the complaints made against that person. And what I remember the story was that law enforcement couldn't do anything about it because the victim decided not to press charges, and the cops kind of said, well, we knew there was risk and danger, but there was nothing we could do. And
Right.
then the law was expanded to include law enforcement, but it sounds like you're saying law enforcement was part of the original group.
Yeah, no, law enforcement has been able to file petitions since the beginning. And in fact, Colorado's actually it's at the low end of the proportion of them that get filed by law enforcement. But even with that, law enforcement still files, like in a given year, anywhere between 65 and 70% of the petitions that are filed.
Okay.
So they're also the most typical petitioner.
Okay. And then in 2023 or going into effect, I think in 2024, district attorneys were added
alongside healthcare and mental health professionals.
Right. Okay. All right.
Yeah.
Got it.
And licensed educators, right? Licensed educators.
Educators operating within any sort of educational setting. So that again, that could be K-12, right? And that creates a different dynamic. But then also in higher education settings, so in college or graduate school or
Okay.
But even but again, that has to have it has to be your professor, it has to be your teacher, it has to be it can't be just a rando.
Yeah, you can't just like file against anybody, right? And that is one of the things that I mean, I think that in some ways we've done a bad job of like sort of excuse me, providing good education to people about is that you can't just file it against anybody, right? Like I think a lot of the times, especially when we're talking to clinicians, right? So if we're talking to mental health or healthcare professionals, they think about this kind of like they would think about mandatory reporting of child abuse, right? Like where, at least historically, what has been the case is like if you, and even me as a licensed clinical social worker, if I was aware that a child might be being maltreated or neglected or whatever, I had a duty to provide that information to Child Protective Services to investigate. But irrespective of my relationship with whoever it was that I thought might have been doing something wrong, this has never been the case with ERPOs, right? So like I have to have a specific relationship with that person, including educators. So it has to be like, again, yes, your professor, your school administrator, your somebody like that.
Okay. So I just want Joseph is in the chat asking questions. I would just want him to know we're going to try to get to these points, but I just want him to know like it might not happen in the order that he's asking about it. So we try to engage with our commenters because it does drive a lot of what we talk about.
Fantastic.
So I'm just pulling up the Colorado Revised Statute around this just so I have it in front of me. But for those who are interested, do you know it off the top of your head?
1812 I'm sorry, 1813 14, 1813 14, and then the ERPOs is 1314.5.
Okay.
So
All right.
I'm one of those weirdos
on these things, so he knows this stuff.
He knows his stuff. Okay, so Edgar, do you have any questions?
No, I think this is going to be one of those podcasts that tends to happen from time to time where I just kind of take the backseat and then talk when it's appropriate.
Okay.
Um,
Because I have a bunch of questions. So.
Correct. Chris and I have had conversations. I definitely have some stuff, but I think in the interest of having good communication and effective communication, I'll let Isaac ask all of his shit.
Yeah.
Okay.
If we run out, then Edgar and I will just do like a re-dramatization of we've had elsewhere. Yeah.
So you said that you had started to learn about what the GVROs were doing in California.
Yeah.
They have had one of the longest histories of these types of laws. Is that correct?
Of the sort of current iteration of them. So actually the very first like risk-based, warrant-based actually ERPOs, as you might call it, came in 1999 in Connecticut. And the one after that was 2004, I believe, in Indiana, of all places, if you'll believe that. Both of those are sort of fundamentally a little bit different than what we talk about in Colorado or California or Florida or New York or any of these places now, in that they were warrant based, right? So basically anybody who wasn't a law enforcement officer could only ask law enforcement to seek a warrant to then investigate, which they would then have the ability to file with the court if they thought that it was appropriate, right? Now, all of that to say, like, so it existed in Connecticut and in Indiana for, between 10 to 15 years. And then later on, there was sort of this second wave of them that included places like California.
Okay. All right. As usual, California gets blamed for other people's problems. So I did not know that Indiana had a form of this law going back that far. So,
what often happens, if I could just editorialize, just like a little bit, what often happens is, and this probably isn't a surprise to anybody on here, is that passage of these laws predictably follows a big tragic traumatic event, right? And in Indiana, I believe at the time it was an individual who came and shot several people at his former workplace, which I believe was a FedEx distribution facility.
Oh, okay.
So the political will to pass that, or the impetus to pass that, was the tragedy at this FedEx facility in Indianapolis. You can watch that kind of happen with respect to other states passing them. In California, it was the Chula Vista shooting. In Colorado, it was Deputy Zachary Parrish getting killed, et cetera, et cetera. The legislative cycle tends to like sort of operate in the way that like you can't always necessarily tie it back to that. But if you know the event that you're looking for, then you can typically see like where that will, or that sort of desire to pass it, comes from.
Okay. So in Colorado, there is in the law in 13 14.5 104, it also mentions community member. Can you clarify what that means?
Yeah. In those, so the community members,
it does define it. If you go
it does define it.
Yeah, it does show it in the definitions. And the community member, if I remember correctly, is the medical professionals, the licensed educators, and all that shit.
And then also family members, roommates,
household members,
parents, household members. Yeah.
Okay. Oh yeah, there it is. In 14.5102, community member means a licensed healthcare professional, mental health professional, who through a direct professional relationship provided care or education, direct professional relationship. Okay. Because a lot of times people will hear one word and they'll make their own logical jump to what that means, and then it becomes dispersed in the group of knowledge, either correct or incorrect. So, and I was one of those people. I assumed that community member meant anybody who has some kind of a direct relationship, but it's just defining those medical and educational professionals. So, and then I think in 2026, the current legislative session, they're talking about expanding it to any medical professional, not necessarily licensed. Is that correct?
No, what's proposed in the current legislative session, so in SB 004, is to clarify the list of petitioners such that institutional entities who employ people who are already able to petition. So if I were a doctor at a hospital and I wanted to file one on a patient who I'd taken care of, it wouldn't necessarily have to be me who was filing it, but it could be the hospital itself that was filing it. And then the other clarification that is in that bill is to specifically note co-responders, so mental health professionals who often co-respond with law enforcement or EMS services, or sometimes fire protection services, so that they would be seen as eligible petitioners in cases where like they encounter somebody who's in crisis.
Okay. So you said to clarify, but actually it sounds like what that may end up meaning is that a doctor could potentially gather evidence about somebody's mental health state, and then somebody above the doctor could say this person should have an ERPO filed against them based on these findings.
I think that, so I think that's one way that you could look at it. What's happened, so if I could take a step back, the research that we do in Colorado right now includes and is very tightly based on that we use a variety of public records request strategies to gather all of the civil court documents associated with every ERPO filing across the state, right? So like we tend to be sort of like a couple months behind because you want to like gather them in batches, but we have sort of, for the purposes of this discussion, every ERPO petition document, and then any case files that were associated with that within the case record that aren't like sealed or have been expunged or things like that, right? So judges can decide to seal various pieces of it, even if they don't seal the entire file, and so we obviously don't have access to that. But one of the things that allows us to do is it allows us to see like who's being filed against, where are they being filed, what are the relationships of the petitioner and the respondent, so like who's filing against who, what are the kinds of things that are being alleged, right? So like what kinds of threats are they allegedly making that then make a judge think either I should grant this or I shouldn't. And also what other things are people saying in the petitions to try to convince the judge that this is the step that they should take at this particular moment. And so in that, one of the things that we've found out is that when so we don't have access to any that involve kids, right? Like, and I think there's actually good reason to believe that in Colorado there haven't been very many, if any of these filed against minors. But if there were, but where we have seen educators file them were universities. And in the cases where universities have filed them, there have been a couple of them. And in both cases, what happened was the regents of those universities listed themselves as the petitioners, right? Like they didn't even ask permission to do it, like it was that. So it wasn't Professor Kanopke, it would be the regents of the University of blah, 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 right? And so and I think that has, I think that has some strengths with respect to not just like what you would do for data gathering and what I think you're talking about here, but also for the process that then sort of naturally has to occur in order for an institution to sign on to that. And I'm happy to like go into greater detail about that and why I think that's advantageous from a firearms rights standpoint. But I think that part of the goal of clarifying that was not to necessarily like empower an institution to just file willy-nilly, but it was it would be to sort of protect the safety of the petitioner, but then also to ensure a little bit of a more equitable process.
So in this case, it would be the professor. We'll just use the hypothetical that was making the recommendation or wanted to do it, but then the responsibility falls on the institution. Is that what you're saying? Kind of like from big picture point of view?
Yeah. And so, and actually, according to SB 004, like either case could still work, right? So if the individual professor wanted to file it on their own, they would have legal standing to do so. Or they could pass it along through the chain of command, and then the university or the health system, right, if it was a doctor or whatever, could then file it on their behalf using information gathered from whatever process they use.
Could a scenario exist where the professional, the professor or the doctor, does not have any intent to file an ERPO, but the institution takes the information and decides that that's the course that they want to take?
That's a good question. I don't know, honestly. Okay. And that certainly hasn't been tested. That I don't believe that has happened.
Okay.
I don't know if it could theoretically happen.
Okay. All right, cool.
It can't happen right now, though.
No, like institutional petitioners can't really happen right now. No.
Okay.
In Colorado.
Yeah, or anywhere, really. So.
Yeah, because there's nothing in the law right now in the state of Colorado that would allow that. That's what they're trying to change. Mm-hmm. And this is where on our side we share the hyperbole of what is RMGO calling this, the kidnapped kids allegiance, or I forget what the fuck they're calling it, because it is the education system, like raid your home for the kids, right? I forget exactly how they're
yeah, I mean, just from my own experience, I was a homeschool kid in Southern California in the 90s, and this feeling about the government taking your kids away from you because they don't agree with you has been around a long time. So ERPOs are not anything new with that. And again, like, not trying to get into the morals of this, but just understanding that perspective exists in, let's say, maybe a little bit more independent minded people, that the moment that you invite healthcare or the education system into decisions that happen inside the home for the well-being, not abuse, but well-being, homeschooling as an example, tends to rile people up from a point of view of like, are you going to come take my kids because you don't agree with X, Y, or Z or something like that? So
I think it is important right now for those of you guys that are just tuning in. We've got Dr. Chris Kanopke discussing ERPOs. and we're not having a discussion whether we agree with them. Guns for Everyone National is completely against them. Would never support them in any way, shape, or form. I just want to kind of catch you guys along, but we are having a conversation about facts. That's where I want to frame it. We will get to your questions, so if you have questions about it, please ask the questions. But Isaac is kind of on a roll. He's probably pissed off that I'm interrupting right now. I'm going to let him continue his role of asking questions.
um, so Doug asked, so it must be a person who has a direct relationship with the person they are reporting on. And that direct relationship would be familial, household, educational, um,
You
uh,
bump into those?
medical, or some kind of law enforcement relationship, meaning there's law enforcement contact due to some kind of a complaint.
Right.
Okay.
And you said that about 70% is law enforcement?
Yeah. In California, it's closer to 95%. Are filed by law enforcement.
Okay.
In Washington, it's somewhere in between. It's like 80 to 85%. And then in Florida, actually, where there's a lot more of these being filed than anywhere else, it's sort of another thing that's, I think, a little surprising. But law enforcement are
Not if you've ever been to Florida.
but law enforcement are the only eligible petitioners, right? Like there's nobody else who can file, like what family member, healthcare professional, otherwise. So
Okay.
yeah, but no, Florida is the gunshine state.
Yeah, I mean, I've only been to Florida once, but I ran into Florida man like 3 times in 24 hours. So like, that was a little surprising.
It can happen.
It's going to be hard to talk about numbers
Yeah.
without, couching it. California's population is so much bigger than Colorado's population. So percentages are probably going to be more useful to us.
Yeah.
So if we were to say, well, how many ERPOs are filed in California versus even Florida has a huge population compared to Colorado. But that number of 60 to 70% for Colorado for law enforcement, is there a trend across all states that have these laws that tends to show that it's law enforcement that tends to be the highest percentage?
Yes. I think universally, across the states that have them, law enforcement is more than 50% of
Okay.
eligible petitions.
From your research, why would you say that's true?
I think that one of them is just exposure, right? So it's like the law enforcement are the people who we call when something is scary and dramatic, and particularly if something is scary and dramatic and involves the potential for firearm-related threats, right? Those are not things that typically, just everyday citizens are comfortable dealing with if they don't have to. And so I think that's sort of the baseline case for it, right? The rest of it, I think, has to do with that there are processes that get built both intentionally and unintentionally within systems, whether they're like healthcare systems or state governments or agencies or otherwise, which with ERPOs in particular, kind of make an effort to funnel potential cases toward law enforcement, which I mean, if we wanted to talk about like whether that's a good or a bad thing, I think is like sort of a matter of opinion, but I do think it has some strengths with respect to rights considerations as well. And so I think that's probably why you see the most of them that are filed in that way. The other thing that happens is that law enforcement might be more apt to file because they know more about people than others who are sort of peripherally related to them, right? So like not necessarily family members, but a law enforcement officer might know we've been called to this house, 10 times in the last month. And he's been saying this, that, and the other. And he has a history of having been arrested for this other thing. And we've thought about other courses of action that we could take, and have elected to make this part of the package, if in the way that they do.
So my mic went out for a second, so I might
No,
sound different. So it sounds like there's like an element of when you call the police, you kind of ask them to take care of it. Like whatever that means, here's all the problems. Is there anything you can do? Kind of dynamic. Is that?
Yeah. Yeah, I think most commonly when people call the police, they don't necessarily ask for something specific, right? Like they don't say like, I want you to file a red flag law on this guy, but they might that might become part of what gets pursued, particularly if there aren't. And this is just like speaking anecdotally about our interactions with law enforcement. What a thing that you should know if you don't already is that law enforcement, as a group, now any one individual might be different, but like as a group, tend to be very big Second Amendment advocates, right? Like they tend to be on the side of protecting firearm rights and protecting constitutional rights sort of writ large. In that way, they have firearms on them all the time. They feel like they're tools to use as part of their job, rather than any of the other stuff that might get sort of attached to them. And so oftentimes I think we think like convincing law enforcement that this is like a thing that they might want to use would be easy, but it's not. Like people who are on the ERPO advocacy side are often frustrated that law enforcement aren't more excited about taking this up as a thing that they might do. And one of the ways that we see that kind of play out, actually, I mean, I don't know if you're going to get to this later on, is that ERPO petitions in a whole bunch of different states are really highly localized, right? So in California, a surprising proportion of them are from San Diego County, very specifically San Diego County, not the Bay Area, not Los Angeles, San Diego County. And then if you go to Washington, perhaps not surprisingly, it's in Seattle, just because it's densely populated and the politics are a little bit different. In Colorado, it's a little bit more diffuse, but still a big proportion of them are in Denver. And then you see some similar dynamics in other states, but really, some of that's about like the local sort of feelings and values, but it also has to do with whether law enforcement has sort of like really like taken this up, like they've adopted this as like central to their practice.
Has there been any surveys of police officers in any capacity around how they approach this problem? Not problem meaning like just the general structure of like people in crisis with firearms, and how they, like, I'm sure there's a ton of research on police officers in just general domestic violence situations, but do we have any ERPO data or even anecdotal around law enforcement and ERPOs?
Well, so we have a little bit of both. So we actually about a year ago conducted a survey of a random sample of law enforcement officers across the state of Colorado, as well as sort of anecdotal stuff that we've been able to gather, just sort of in our travels working with law enforcement across the state. And so some of the things that I think come from that are that, for one, if you talk to law enforcement one-on-one, as I said, they tend to be sort of generally a little bit skeptical of using ERPOs, even though they're the ones who most commonly file for them. And what you'll say is, if you put in front of them, like, here's like a hypothetical case and here's all the things that are going on, what you'll tend to see is them walk through like a list of like other things that they would consider doing before they got to that point, right? So in a domestic violence situation, I think one of the first questions they would think is like, well, can't we arrest them for domestic violence? And then, then we're following down the criminal path of enforcement and separating a dangerous person from firearms, rather than these civil orders, which are seen a little bit differently. Similarly,
so just to kind of clarify down that path,
yeah.
If they're arrested on a DV charge, then there's somewhat of a de facto red flag happening because of court proceedings in a criminal case. Can't have access to weapons. You can't handle firearm. Like any criminal case is typically going to have that as part of a pre trial condition and conditions of a plea and things like that. Right? Is that correct?
So here's where I should say I'm not a lawyer, right? So like, don't take anything that I say as like legal expertise or advice.
He's a lawyer.
Edgar finished right in front of me in our class in law school. So, no, but so at any rate, it's a pretty common condition within domestic violence proceedings that there's a domestic violence protection or a restraining order that gets placed, right? And some of those are attached to the civil legal system, and some of those are attached to the criminal legal system. And in either case, those have sort of a longer history of use, right? Those exist in all 50 states plus DC, and are much more common than red flag laws. And what'll happen in those very often, I'm trying to remember where I was coming from on that, is that the firearm restriction is often like a checkbox that can be like included among a raft of other things, right? So in a domestic violence circumstance, you'll commonly have, no contact, like you can't get in contact with the person, you can't be within 500 feet of them or anywhere that they work or live or whatever. And you also can't have access to firearms for some period of time.
Yeah, and that has a long historical record of managing risk around people who are suspected of especially violent crimes. Right. And we're not going to get into that whole thing.
Yeah.
So Joseph brought up the point: cops are not skeptical; they just can't enforce red flag laws how you think they can. The cop has nothing to do at that point with enforcement. It is just filing the petition. Is that correct?
Right.
If they chose to do so.
About filing the petition as well. And some of that might be about their thoughts about enforcement and what it would take to do so. So like, I think both can be true.
Okay. I see what you're saying. So let's talk. Oh, I feel like we're jumping ahead, but let's just talk about enforcement for a few minutes. Enforcement is going to come first with some kind of a notice. Is that correct?
Yeah.
That petition has been filed or approved.
You got a turbo first, right?
The turbo first, right? So maybe we take a step back and sort of like just walk through a little bit of the process, right?
Yeah,
so
let's do that. Yeah.
If once an order, once a petition is filed, let's say it gets filed with the county civil court in the jurisdiction where the respondent lives, which is the requirement in Colorado. It does get seen by a judge or a magistrate. Now it differs county to county, like who that judge is. They're always civil. In Denver, it tends to be seen in probate court. Excuse me. In other counties, it can be seen in probate court. It can be seen in family court. It can be seen in just sort of general civil. And sometimes those aren't different people because, in very small counties across both the western and eastern parts of the state, there aren't huge civil court systems to like differentiate on. But at any rate, it gets in front of one of those people, typically within business hours. Like these don't happen in the middle of the night. They don't happen on weekends most commonly. And what'll happen then is there's like a hearing, but it doesn't include the respondent, right? So like this is one of the fractures with respect to like where people disagree on the due process elements of ERPOs. But there's the turbo hearing at which the judge decides whether to approve or deny the temporary emergency extreme risk protection order. If they decide to grant it, and they don't, they decide to deny them roughly 40% of the time in Colorado. That's something
for the turbo.
At the turbo phase, like at the first phase, right? So it is indeed possible that somebody could have had one filed against them and they would never even know it because it got denied at the initial stage and then nothing happened based on that. We do actually know about those in Colorado because we have access to all of the petitions. We don't necessarily know the same things about other states just because they have different laws about what you can access from public records requests. But either way, so let's say though that they do get granted the temporary ERPO, so the turbo. What happens then is the judge says, okay, this has been granted. We have 14 days in which to hold a hearing for the full year ERPO, right? So like you can't grant the entire full year one at the turbo hearing. What happens then is the judge tells law enforcement, whether they petition for it or not, that their job now is to serve the respondent within 5 days. and notify them of the hearing. And so like they're saying, we're setting a hearing, it'll be Tuesday the 10th at 10 o'clock in the morning. They have to be here. And law enforcement has to serve it. Law enforcement's the only one serving it. There's no process servers, none of that kind of stuff that you would see in for divorce cases or things like that. Law enforcement has to serve it. They can, although they don't always file for a search warrant, which they could use to search the respondent's property to make sure that they were gaining access or getting the person to relinquish all their firearms. It can happen other ways, in ways that don't necessarily follow the statute, and I'm happy to talk about that.
Yeah, well, so just on that
Yeah.
note, do you have any kind of data on how often a search warrant is applied for and used in these service? Or
It heavily relates to jurisdiction.
Okay.
So in the counties that do them more frequently, it's more common for a search warrant to be filed for. So that tends to be Denver or Boulder, and then some of the other more populous states or counties within Colorado. Less commonly in other ones. What'll happen in every circumstance, though, is there's supposed to be documentation of relinquishment or the person doesn't have access to it. And so what that can look like is at service, the officer can essentially hand the respondent or their representative, and this is something I want to come back to, a piece of paper that says, what firearms do you have? Where are they? Do you have any in the first place, right? So it is actually reasonably common that the respondent will say, I know that they said I was threatening them and it related to firearms, but I don't actually have any. And that may have been in the petition itself too. Like we've seen ones where they'll say like they said that they were going to get a gun and do X, Y, or Z, even if they don't have one yet. But they could also say, I know that they thought I have one, I don't have one, and I'm willing to attest under penalty of perjury that I don't have any firearms in my possession or control. And so then they can sign the thing and give that back to law enforcement.
Can they sign that under penalty of perjury if they've already removed the firearms from their possession?
Right. Now, what they might say is, so yeah, they'll say, I don't have any, or, that person said that I have these ones, but I gave them to so-and-so. And sometimes law enforcement or the judge is satisfied with that, and sometimes they're not. Because the concern being, if you said, I just gave him to my brother and he said he's not going to give him back until the order's been lifted, it's whether they trust the brother or not, sort of effectively, right? Whereas the other options that are sometimes exercised, although it's not necessarily laid out in statute quite this way, is that they'll follow the path that's more common for those domestic violence restraining orders, which is where they'll say, okay, you have some amount of time to give us evidence that you've relinquished them, either by giving them to law enforcement, and then we'll say like we took gun A, B, C, and D into evidence, and we're storing it for you, in our evidence room or whatever, or to a federally licensed firearm dealer, so to an FFL, where then they will give you some sort of receipt saying like we are storing these firearms, and you can submit our receipt to the court as proof that you relinquished them, and they wouldn't be able to access them because once the TERPO has been granted, the person's information is uploaded into NICS, and so they wouldn't be able to pass a background check to get them back until it's lifted.
Okay. So Edgar, you know more FFLs, you talk to more FFLs than I do. Do you know any that have been involved in this process in the way that Chris was talking about?
So I don't know of any that it got to that point and it was, the short answer is no. But I do know of many that held before it got to that point. It kind of as
voluntarily.
A preventative thing.
Okay.
I can't. If it has happened, they haven't said anything.
Yeah,
but I don't know.
So we've done other projects with FFLs, like so for like the firearm storage map and other things. And one of the things that I think is pretty universal is they'll say, if they've been in business for a little while, they'll say like, yeah, we have people who come in because they're subject to restraining orders. Usually they mean domestic violence restraining orders. So that part is at least familiar to and pretty common for people. Now, whether they've been involved in an ERPO is a different question and probably not super common.
So as far as the legal system, just to put it all under one group, as far as their knowledge about what firearms you have or don't have, it's really, it sounds like it's either self-reported or the result of a search warrant.
Right.
Okay.
Yeah. So since there's no database, there's no registration, there's no anything like that in Colorado. Effectively, when law enforcement is looking for, let's say they're supposed to serve this order, right? Like that's already been set. They are looking for either information that they have based on previous interactions with the person, or typically reports within the petition itself, or somebody who reported to them. So if they were called to a scene and the person said, "Yeah, I would," like, we know that that's what you're going to do, and he has this gun here, this gun here, this gun here, this gun here, then that's the information that they operate from. There isn't like a more administrative way to do it here.
Okay. All right. So the person is served and the firearms are removed either to an FFL, to the hands of law enforcement, or if the court is open to it, to some other third party
Yeah.
that is basically promising to the court, really, that they're going to hold on to them.
Yeah. And the third party is technically not allowed in statute, although it happens in practice, I think sometimes. Where in statute it says that the third party, so like a friend or family member, could hold on to firearms. In the case of an ERPO, is if it's a curio or a relic, right? So like technically it's like a firearm that's over 50 years old, or has significant historical or financial value.
Okay. So it's lawful in Colorado to transfer a firearm to a family member as a bona fide gift, but it sounds like what you're saying, that doesn't apply in this case.
Oh, that's an interesting question. I have not seen that, like where somebody's like seeing the ERPO coming, and they're like, so then they gift their firearms to somebody,
Their brother,
to their brother, whoever
Yeah.
else. I don't know that I've seen that play out specifically. I mean, I think that, if I were the judge and like my job was about like enforcement, I'd be like, really? Like right now is when you decided to do that. It wasn't like on his birthday, like or whatever.
Okay.
And so I don't know that that's played out, but yeah,
Okay.
in theory, I guess that's something.
It's a question mark.
Yeah.
You said you wanted to talk about the person's representative
Yeah.
being served.
So one of the things that is completely unique to Colorado is that we have like a system, and it's built into the statute, where anybody who is a respondent to these is allowed to and can have supported legal representation for the purposes of the ERPO hearing, and then anything that results from that, right? So we didn't actually get in that whole cascading process to the hearing, but if someone was a respondent to an ERPO in Colorado and they didn't have a lawyer who they wanted to work with and pay on their own, the state is obligated to pay for an attorney to represent that person in their court proceedings. And it's actually pretty commonly taken up on, right? And I think they've sort of got the state and the Department of Law have gathered together this sort of like almost resource database of lawyers who are interested in representing respondents to these orders. And I think that they, having talked to a few of them, I think they come to it for a variety of reasons. But it's an interesting due process protection that exists only in Colorado, and it bears noting that that petitioners, so the people who are filing the petition, don't necessarily have legal representation. Now, if they're law enforcement, then they have the city attorney or whoever, right? If they're a medical institution, then they obviously have general counsel or whoever who might help in that process. But if you're a community person and you're a roommate or a spouse or whoever, you don't necessarily have a lawyer. But the respondent definitely does, or at least can, if as long as they say yes.
Okay.
Money's not going to be the impediment to that, and that creates some different dynamics, I think.
So it doesn't operate under the same rules as a public defender and your income and resources.
Right. No, like I believe you can just like ask for one.
Yeah. Oh, okay.
Well, one thing that I'm not a big fan of, besides the entire fucking thing.
Yeah.
So let's set that aside. Besides the entire law, one thing that bothers me, and I want to see how, just because we're talking about the attorneys and all that stuff, if there is even a way to calculate this, or if it even matters. And now that I'm thinking about it, it probably doesn't. But in the state of Colorado, the person filing the petition only has to present a preponderance of the evidence, and the quote unquote defendant, it has to fucking 100% beyond a shadow of a doubt. So like, I file against Isaac. I just have to show that it is most likely that Isaac is a danger to himself or others.
That it's more
Isaac,
likely than not.
Isaac would have to prove 100%, essentially, or as close to that he's not a danger to himself or others. So there's this big disparity in how that gets played out. Is that true? Is there numbers on that? Is there? I don't know that you can find numbers on that.
Yeah, I don't. I mean, I think it'd be interesting to look at from a couple of angles. So, but Edgar, this is why you finished in front of me in law school. Is that like you have, I'm not an expert in standards of evidence, right? So, like, I think the question is like, so the petitioner has to illustrate at a preponderance of evidence, right? So, like 51% likelihood or more that the person is a risk of violence, is it an extreme risk of violence. Whereas I think the supposition is then in his defense, he has to be like 100 to 0 or 99 to 1. And that might be a perception thing. I don't know if that's like a legal standard, but again, that's not my expertise.
Yeah.
Edgar, do you have a something in the statute that you can point to for that?
I thought you had it up. Yeah.
Yeah. I sort of had it up. I don't have it up like you have it up.
Where the child is. Oh, by the way, just before we get before we start saying more dumb shit, now that we have Dr. Chris Kanopke, get that.
Yeah,
Dr. Chris Kanopke. You are representing yourself today. You're not representing any entity, any university,
this is absolutely accurate.
Yeah, you are here on your own will. We're not.
Nobody forced me to be here, but I was very happy to do so, and also happy to share, like, because this is one of those areas where like people have feelings, understandably, about what's going on and what the laws are and what they actually mean. And when people have a lot of feelings about it, there tends to be a lot of like information that's out about them, and not all of it's accurate.
Yeah, let's talk a little bit about. So upon hearing matter, the fact finds be clear, convincing.
Clear and convincing evidence.
So upon filing petition, the court must provide blah, blah, blah before the next court day, a copy of notice. The court may provide section temporary risk protection. Upon hearing and determining whether the grounds for an extreme risk protection order, the court may consider any relevant evidence, a reason act credible, pattern violation, conviction, a conviction of the respondent, history, blah, blah, blah. So I'll have to look it up when you guys are asking questions, but I remember it saying that the petitioner has to have a preponderance of the evidence, and so petition for extreme risk protection order, and then the respondent would need to 100% prove that they are not. So I'll have to find that here in a little bit, but in the feelings category, and I think this is the big issue, is I hate this law. There's probably nothing you'll ever say to convince me to love this law.
I'm not trying to, just so you know.
No, for sure. No, I 100%.
Yeah.
But I think this is where we get comments. So, and I think Josh was, or Joseph, I'm sorry, not Josh, but Joseph was trying to explain, like this idea that in Japan there was over 20,000 suicides in Japan in 2024, and we argue this a lot, and it's tough to get to a place where we say yes, people are still going to try and commit suicide other ways.
Mhm.
And as disgusting as it sounds, we want them to try the other ways.
Mhm.
It's fucked up. It's twisted in the head. But at least here in the United States, handguns are 90% lethal. And
Mhm.
90% of the humans who attempt suicide with a firearm are going to succeed. If they use any other means, it's the opposite. And this is where it's tough to argue past the feelings of I hate this law. Yeah, I hate this law. I don't like this law. It's an infringement on our rights, all that stuff, all that jazz. But I think it's important for us, and this is Isaac and my position, is if we are going to argue against them, we have to have better arguments than, well, they're just going to try and kill themselves with others. And like, yeah, that's literally what people want to happen is if you try and take pills, you're not going to be very successful. And this is why we in on the gun side have to push for more of the voluntary stuff. Be aware of I get mad, I get sad, I maybe don't lose. I maybe I don't have control over my feelings like I thought I had control over my feelings. Like, so when we talk about the emotional stuff, these do bring up a lot of emotional conversations from both sides.
Right.
From the anti-gun side, it's well, take their guns so we can save one life, not understanding that maybe it can potentially kill a life by taking the guns. I'm a human who's pretty. I mean, you guys all know how I feel about life. I'm ready for it to be over, not necessarily suicidal. And I know for me, red flag laws do not jazz me up to go talk to a therapist. So I know at least for me, it's not going to encourage me. Like we know this, but we have to have better conversations about the subject with facts, and this is what we're trying to accomplish here. I think.
Yeah.
Um, I don't know what you were going to say about feelings. I've got to look for this shit so that Isaac doesn't yell at me. Um,
I think if you were talking to me, I think there's a lot out there, and I think having a conversation about accessing mental health services and what that means in a state that has ERPOs, and particularly in a state like Colorado, where a behavioral health professional is allowed to file directly, which is not the case in most states. That have ERPOs, what that looks like and what I think some of the like dynamics around there are. It's I mean, some of the other things that I think like that are like just sort of like baseline like stuff that everybody should understand is no, you can't file against anybody, right? Like even if my neighbor came outside, if they were waving and pointing a gun at me and threatening me, all I can do is call the police and ask them to deal with it, right? The I can't file against my neighbor in that circumstance because I don't have the appropriate relationships with them. There have been a few circumstances like that have been attempted, but they get dismissed at the outset because the person doesn't have standing. Like they don't get past the turbo phase. The other one is that like we're not seeing a ton of malicious petitioning, right? Like so ones that are identifiable on its face as being like an attempt to harass the petitioner, or at least as far as we can tell, otherwise try to gain leverage in some other kind of situation, right? So there was one in Colorado very early in 2020 that was covered by the media, where there was a person in Fort Collins whose son was a college student at CSU, had experienced a mental health crisis and had basically provoked the police into killing him. Right, so it was a suicide by cop, and the mother had this understandable, lots of feelings, had a longstanding problem with the officer who shot her son, and very early on petitioned for an ERPO against that officer. And then in the petitioning documents indicated that she shared a child with the person as like the evidence that like that she had standing to file against him. Well, long story short was that like that petition got denied on its face because she didn't actually have the relationship with it, and the AG's office filed perjury charges against her. So she was actually like charged with a felony based on having done that. There are a couple of other cases where people who are, including people who are incarcerated, tried to file them against COs in their facilities, which is like, it's a little bit funny on its face, but it's also a little bit harassing. But we're not seeing, this sort of like avalanche of petitions being filed in a way that we can tell is malicious. Are there ones that are filed that are malicious that we can't tell? Well, if we can't tell, then we can't tell. But I think the take home from that is like, that's not a super duper common thing.
So on that note, let's talk about some numbers for just a minute.
Yeah.
What is the per year number we're looking at for Colorado for ERPOs filed, if we have that number, and ERPOs that get far enough to actually enforcement?
Yeah. So in Colorado, we're hovering now, and like, so it's sort of 2020 would be like this, 2021 would be like this, 2022 would be like this. We're sort of plateauing now. I don't know that we're going to see a ton of growth unless something changes. But we're at right about, between 150 and 175 petitions unique petitions that are filed per year.
Okay.
So that equates to roughly 3 a week across the entire state.
Okay.
And so what you think about that number is what you think about that number. Roughly 50% of them, give or take, get past are granted at the turpo phase, right? So like that actually result in law enforcement needing to serve these on individuals, and then the hearing being filed, or the hearing being scheduled and executed for the full year order. Now, when you get to that phase, then it's roughly another third then past that point that don't proceed beyond that, based on what they hear at the hearing. And then there's also like a small but not insignificant group of them. So, roughly, 5 to 10% per year, that where the turpo gets granted, the hearing gets scheduled, it gets served, but for one reason or another, the hearing never happens, right? So sometimes that's because it's often in the case when law enforcement are filing, that then they decide to pursue a different avenue. Like they decide to charge that person with a felony and arrest them and, take that kind of approach. Or in cases where it's like domestic violence, then maybe the petitioner, so the domestic violence victim, gets counseled to instead pursue like a domestic violence restraining order, which, in addition to addressing firearms, also addresses the stuff we were talking about earlier, like physical contact, phone calls, text messages, all that stuff.
Okay. Those are some good numbers. So if I'm doing my math correctly, roughly, and this is on the high side, about 50 a year are being approved at the hearing level, not the turpo level, but the actual hearing itself. They're being the ERPO is being approved.
Yeah, that's about right, give or take.
Okay. All right. So Edgar's got the law up.
Yeah, 14.5103 subsection 3. If a court finds by a preponderance of the evidence that, and this is at the turpo level.
Mm-hmm.
So the standard of the way of evidence or the burden of proof is read slightly different depending on what level it is. But at the turpo level, it's by preponderance of the evidence. And during the hearing, the respondent has to prove 100% otherwise based off of that same.
See, I would think, and again, now we just get to be lawyers now, right? Like, this is
lawyers.
So I think the reading of that is supposed to be that, like, if you're the respondent, then what you need to illustrate is beyond 50% that you're not a threat in that way. And it's just that, like, that's actually like a very high amount to need to overcome compared to beyond a reasonable doubt, right?
This is if a court finds by a preponderance of the evidence that, based on the evidence presented pursuant to 14.5105, respondent possesses a significant risk. This is at the turpo level, so the respondent is not even there.
Mm-hmm.
Only.
What is? Although I believe the same standard applies to the ERPO hearing.
Okay. So, on what grounds, if you have any data on this, are because you said roughly half of the turpos are denied. Do you
Mhm.
know what kinds of grounds that those are typically denied on?
Yeah, we don't often have, I mean, so sometimes we have, like, there's a statement from the judge about, like, what they think it was. Usually it's, we just get this little letter, it's basically a form letter in there that say, like, that they don't meet the standard.
Hmm.
And so that can mean that, like, the judge just wasn't convinced by the evidence that was put in front of them. And we can't really take more than that. What we do know is that those are more likely to happen in certain circumstances than others, right? So, and without having the specific numbers off the top of my head, and I apologize for that, that's more common where the judge will say, like, that they don't meet the standard when the person is only alleged to have threatened themselves, right? So, like, all that's in the petitioning document is somebody said, this person said that they're threatening suicide, and not that they're also then threatening people close to them, or threatening a mass shooting or something else like that, right? That's more commonly the case, that when somebody is threatening others, that it's more likely to be granted based on that.
Yeah,
Okay.
so just really quickly, yeah. And Pincus did put this over on Instagram. We're on X, Facebook, all kinds of like 17 different YouTubes, and also on Instagram. But I did find it, yeah, it is for the temporary is preponderance of the evidence.
Mhm.
Or the permanent, it is clear and convincing
Oh,
evidence.
it's clear and convincing. Yeah, good call. Very good.
So
So,
sorry.
just maybe you know this, maybe you don't, Edgar or Chris. For a normal restraining order, like a threat of violence, domestic violence or whatever, I would assume that there would be the same standard for a temporary restraining order for just domestic violence, preponderance of evidence, just to get that temporary one in place while the case is being evaluated.
I actually don't know.
Okay.
That's a good question. I know that it may be complicated by the fact that there are multiple types of domestic violence restraining orders and multiple pathways to getting there. Some of which involve only civil legal procedure, and some of which involve criminal legal procedure.
Right. Okay.
But and they may have different standards of evidence too. I don't know. Sorry about
Okay.
that. Yeah.
So, and then
How dare you?
Tisha asked, "What's the length of time between a Turpo and an ERPO?" And Edgar said 14 days. It sounds like in the statute,
Yep.
14 days from the date the Turpo is approved till the day of the hearing.
Correct. Yeah.
Okay, the ERPO hearing. All right. So, and again, I'm going to give the caveat that Edgar has. I don't agree with this in any way. However, if you ask a random Second Amendment supporting gun owner in Colorado to guess how many ERPOs are approved by the courts every year, I doubt any of them would guess 50.
You think that they'd guess higher?
I think they would guess higher.
Yeah.
Yeah. And I'm not saying that as like it's okay that they exist.
Right.
It happens so little, but I think going back to the evidence, if you're going to talk about this, have some idea of how much this is actually happening. And if we talk about ERPOs as a suicide prevention tool, if we look at these hard numbers, this is a pretty small impact. But something that I think would be a lot harder to measure would be the impact of the focus on suicide prevention from a medical, uh, criminal justice, institutional point of view on focusing on how do we reduce overall suicide, because FIPPI is involved with the FFL safe storage map. FIPPI is involved with providing gun owners with good education and even in some cases actual hardware for storing guns safely. And we do know from the evidence clearly that the more steps you put between somebody and their method of suicide, the less likely they are to attempt that method, and maybe even attempt altogether. I'm not saying ERPOs are the tool, but if we're talking about public health and suicide prevention, this is we have to present the whole picture. We have to try to get a grasp of the whole picture. And a lot of the people who are involved, like yourself, in the ERPO data and the ERPO education, are also involved in several other suicide prevention projects, that I think, especially over time, we are going to be able to point to and say, this is working, this is not working, and how do we improve the things that are not working, and how do we improve the things that are working and get to a point where we're making a real impact.
I
Um,
I do want to add really quick before you answer, Chris. Sorry,
No.
and this is, I think it's consistent with what we say, because Chris is about to talk about how there's evidence potentially that ERPOs do work, and he's only speaking the facts. It's not that ERPOs work. Again, to Isaac's point, it's the separation between the human and the method that works.
Right.
So I think if we don't want ERPOs, we should have got off our ass a long time ago as the gun community, and we should have been okay with saying, again, recently RMGO like completely lost me. I'm still neutral on RMGO, but they completely lost me when they started making fun of cheesy PSA ads of like, it's okay to text your kids' friends' parents to see if they have guns and if they're stored away, and they labeled it as some commie tactic to take away guns. Like when we encourage that type of bullshit, and it is what it is. Like it's okay to not know what to say and to feel iffy about something is cheesy. But Isaac's had to make these text messages, and I've had to take guns away from people that I care about, and it's not comfortable. But the alternative is they get ERPO'd. The alternative is something else. So I think once we start talking about this, is we have to understand, we want to have this conversation so that you have the numbers, but there is emotion involved with these conversations, and I get it. And if you have an emotion about it, maybe it's because you care. But if you care, your response should not be "Rrrr." Your response should be like, what can I do so that the government doesn't do it for me? Because the government's doing it for you right now because the gun community didn't do a good enough job early on.
Yeah.
End of rant, I think.
No, I appreciated you getting out a soapbox, because if I could borrow it and then get on my own soapbox, I think that the responsibility cuts both ways. And so when you brought up that, that the number is perhaps lower than I think a lot of Second Amendment advocates would sort of guess, if I asked them to guess how many ERPOs would get filed. Part of that is because, like, as in the version that ERPO advocates would offer to either the general population or the Second Amendment community in particular, what they might say is, this is supposed to be for a tiny sliver of the population who is at risk and doesn't affect the vast majority of firearm owners who do so safely, or at least do so in such a way that their guns never shoot anybody, right? And so that is one way that you could look at it. And what that is in the public health approach is what's called secondary or targeted prevention, right? I like to throw in targeted there just because of the funny play on words there, but it's a secondary prevention approach, right? What you're supposed to be doing, you're supposed to use some way of identifying people who are at risk of whatever bad outcome it is, and try to get them specific intervention or support or whatever to reduce the likelihood of some bad outcome, right? And so the examples that exist in other parts of public health are if it's where we have more stringent requirements for a teenage driver, they don't have as many points to lose off their license before they have to go back to driving school in order to get their license back or whatever, right? It's basically we're taking somebody who has shown that they're at risk of doing something that'll hurt somebody, and then providing them with intervention, right? The same would be true for if somebody has high blood pressure, then we intervene with them in a different way than somebody who doesn't have high blood pressure. And what the approach here should be, in the way that now I'm going to get up on my soapbox for, is that if ERPOs exist and people are having their firearms taken away from them in an effort to put time and space between them and the method that they might use to enact violence against themselves or against somebody else, unfortunately, I think a lot of the time, and this isn't just Colorado, this is other places just as well. We kind of think like, oh, we got the guns out of the way, good, and kind of pat the person on the back and send them on their way. And that isn't, and so where the the government or the behavioral health field or whatever is falling short is, instead of saying that, then what we should say is, well, the judge, like somebody said that this person was at risk. The judge agreed. The judge agreed to the extent that they were willing to temporarily suspend their Second Amendment rights because of it. And so, with that as an identifying factor, now we should intervene with that person, right? Like we should get underneath whatever the risk was, right? Is this because there's a mental health component to whatever it is going on? Is it because they're in a relationship that is just unhealthy and sparks explosions, whatever? Is this person drinking too much? Are they using substances in a way that's unhealthy? What about the rest of their circumstance is why they're at risk, and not just the tool that they're at risk of enacting violence with. So maybe we should use that opportunity to approach these people and say, like, hey, we appreciate that this isn't necessarily how you wanted this to go, but since we're in this in this situation, let's see what we can do for you. Do you need help with accessing a therapist? Do you need help perhaps drinking less? Do you need help working on other things that they talked about in there, so that not only is that person, do they have the opportunity to kind of improve their situation and their circumstances, but also as a society, when that person gets their guns back, and most do, that we've done what we can do to help them be safer, more responsible, healthier, and less at risk later on.
Yeah, the intervention is the hard part, I think.
Yeah.
Like getting to a point where you're willing to involve law enforcement, to try a 72-hour hold, to get resources, whatever it is. That's a hard place for a lot of people to get to. They and I'm speaking from experience, want to believe that the situation isn't as bad as it looks. And not advocating for ERPOs, but it's entirely possible that anything in this process could be the wake-up call for somebody at some point to say, oh, there is a real problem here that we need to address. And I think that's just a human problem. We're not that good at that. We're not that good at having those conversations. Unfortunately, now I know from experience, it's way easier to talk to your friend about their access to firearms than it is to give a eulogy at a funeral. But how do I know that? Is from experience. If I didn't have that experience, I'd still be much more hesitant to have those conversations.
Mm-hmm.
And this is a human problem. This is not strictly a government problem. It's not a public health problem. Strictly, this is a 360-degree problem. And I think that's where the opportunity for everybody involved in this conversation is to say, all right, well, we don't want this, but how do we learn how to take responsibility in our own lives to stop these kinds of things where they can be stopped? To Joseph's earlier point, you can't stop every suicide. You can't prevent every negative thing from happening. But the question is, at the end of the day, can you go to sleep at night knowing that you did what you could, as a friend, as a family member, as somebody who's talking, even just to yourself and saying, hey, I'm the one who needs help. Mandated, I'm going to read this, mandated mental health evals would also over time provide data on whether or not mental health professionals agree with the majority of the judicial decisions to issue ERPOs. We need that data. Yeah, I was just thinking that too. We need some post interaction data to talk about this as well. With respondents, that'd be the person who had the ERPO filed against them, with family members. We need to see what the long-term effects of these are to get more data, just, to gather more information. So we're speaking from a point of science and not just feelings. So
And I do have to agree with Joseph. What he said earlier is a lot of these law enforcement humans, including judges and including DAs, they don't always understand the full picture. To Pincus's point, none of these humans are mental health professionals. I mean, you and I, we say in classes and here we're not attorneys, so but yet we don't hold these people to the same standards of, and there is a disconnect there of where we're having people who are not mental health professionals making mental health decisions, and that's a big disconnect, and I think that's why you do get some emotion, but it would definitely help the conversation. It would definitely help how we collect data. How do you guys collect? I don't know if you're done, Isaac, but
Yeah, yeah. Good.
how do you guys collect data? Unless you needed to respond to something that we've said, Chris.
No, no. I mean, at a very basic level, we gather all of those court documents, and then it's actually a fairly straightforward process, even if it's really tedious and really like time intensive. So we gather all those court documents, we put them in, like a secure database, and then we have, a group of researchers who basically fill out a little survey. It's not a little survey. There's like 80 fields in it that they fill out about every single case, right? And then we go through and we have, a couple of people who kind of oversee the project who double check on a certain proportion of them just to make sure that like we're catching the things that we should and not the things that we shouldn't. But what all those fields are include the things that I was talking about before, like, who is the petitioner and what is their relationship to the respondent? Where is this? What are they alleging is going on? What are some other like aggravating case characteristics? So again, like substance use, domestic violence, threats of mass shootings, things like that. We also capture a little bit of demographics about the people who are involved, in particular military and veteran populations, as well as housing unstable, other things that you might sort of be curious about, in order to try to sort of paint a bigger picture about like how these things are working. And that's, when I'm citing the data that I'm citing, that's where that comes from. And it's really due to an enormous amount of work that medical students and some other research staff that we have, as well as myself and a couple other people, just sort of fit into our days.
This is where I think academia and the gun community need to kind of get together more and collect data. Is you you know how I kind of feel about the data collection. I think you know how most gun people feel about the data collection, and a lot of it is who's funding it, and is there nefarious intent with the funder? Is there potential? I know you guys enough to know that at least not intentionally, you guys are not saying we're taking every town money to collect data for every town. Dr. Emmy Betts, for those of you guys that don't know her, you should get to know her. I think she's one of the humans who's actually serious about solving this issue. We don't agree on many things, but again, Isaac just proved that he doesn't even agree with himself. And I don't agree with myself all the time, and that's important. We say this not just as a joke, but it's important to understand we don't need to agree. But I do believe that some of the data you guys collect and again, not intentional. It's just very fluffy, because of the nature. You're giving me a box, so I'm going to answer whatever the fuck you want me to answer because you're giving me something that I want, or you're catching people who are softball gonna, because people think I equate these two, and I have equated these two. Like in surveys, there's like, well, 90 something percent of gun people say this law is okay. Well, if I go to a Mexicans for Trump rally, I can show you 100% people of Mexicans support Trump. But I went to the rally where there, so like I'm always curious about where you collect the data.
Yeah.
And I think it's important for people to understand it. I do believe that you guys try your best, and you guys know that there's a fault to to how the data collection happens, because in research we know this is how many people are lying in the so how
Yeah.
do we ask better questions, and maybe that's something where the gun community can help, even if we don't agree, and some of us more abrasive than others, but
Well, as gun owners, I just want to say that if we really believed that our position was correct, we wouldn't be afraid of more data. We wouldn't be afraid of gathering good quality data. And academia is better at that, I think, than generally speaking, than the gun community is, because you're
I
trained
think
on how to
Fippy
do
is,
it.
I think CU, I was
Yeah.
at that shit in
Okay.
November.
True enough. Yeah. True
I,
enough.
I would encourage you guys to spend some time. I was baffled. And this is why I don't get invited too many times to places, and I get invited a lot more than I give myself credit for. But in Arizona, you did get to see the clear difference on how CU is handling shit and how other entities are handling shit. And from an outsider's perspective, Arizona is doing pretty good on being honest on how they want to collect the data and including gun owners. Most other universities couldn't give two fucks about gun owners and their input and yeah, so that's why that's why you're here. That's why I like being part of FIPI,
Yeah.
even if we have our disagreements. Is I wish more gun people would get to see um, that even if we disagree, and again, FIPI, not you, Chris,
Well, no, I understand.
um, is there's a genuine approach to let's include gun people, and
And
sometimes we don't get that.
No, and I think that part of the goal is to facilitate conversations about what solutions could be, or what is sort of realistic and appropriate to the circumstance, that honors the lived experience of everybody who's involved, right? And one of the enduring false dichotomies, right, that exist in the world as it pertains to firearms and firearm involved violence is this notion that I think some folks might have, where saying like there's people who want to prevent gun violence and there's people who don't care, and that's not really true, right? Like even the most ardent firearm supporters, at least that I know, at least would prefer that fewer people died, especially by suicide, right? Like, and where you get into other things, I think could be a little bit different, but they prefer that less community violence was happening. They prefer that less domestic violence was happening. They prefer that less people are dying by suicide. I think those are things that, like, people generally speaking agree about. And so figuring out what that means, as far as, we're looking at ways to improve conversations within the firearm community about like how to talk to people if you know that they're in crisis, which very much mirror, this is another one of my like soapboxes to get on, very much mirror the efforts that we might take in academia to try to improve the quality of conversations that clinicians are having with people when they suspect that they're in some sort of mental health crisis, including an acute suicidal crisis. One of the gifts of being like the ERPO guy is that I get invited to talk to clinical groups because they want to hear about these red flag laws, that all of a sudden they were like, oh my God, I didn't know that like this was a thing. And now like my patients and the admins are asking about it. We don't really know. Because what that does is it gets me in the door. And what I say every time, and I use the same joke, is that you got to eat your vegetables with this too, right? So like, we're not just like, we'll talk about how like filing works and what a relationship looks like and what it looks like, if you were to actually do this and it actually got to court and all of that. But I want to spend way more time talking about like, how do you competently just talk to somebody about safe storage, right? Like, because both suicide's an icky topic, and I think a lot of mental health professionals are even like antsy about talking about that, medical professionals as well. And then firearms are ones that people I think are scared to talk about, because either they know that they don't know and they know that their patient knows more than they do, or they just don't want to bring up what they think is going to like alienate people, so like that just doesn't become part of the conversation, or they don't want to ask because they know that they don't have like an answer ready, right? Like if you say like, do you keep your guns locked and unloaded and all that stuff. If they say no, if you don't have like, well, what do I say next? Then you're not going to ask that question in the first place. So, but training people about like, how do you have that conversation in a way that's at least competent so that you can go from counseling on safe storage within the home to like, let's consider what it might look like to temporarily, voluntarily move firearms out of the home, either with friends or family, as long as they're legally able to possess firearms, or to, you know, an FFL at one of these sites or somewhere else that makes sense, before we're even like in the same ballpark as ERPOs, right? Like that's something that we would do if like all of these other things aren't working or have failed or just like are inconceivable for whatever reason. But like all of these things are stuff that you should be doing, you know, more or less every time you encounter somebody who's in crisis.
So on the note of data, can you tell us where, if you do, and where you share or publish the data that you have around ERPOs?
So, so in terms of papers, like there's academic journals that we publish in. I mean, that's part of my job. It's not necessarily my favorite part of my job, but it's part of what I do and publish in. You know,
Publishing gets funding.
Yeah, publish or perish, as they say, right? But like, I could, oh my gosh, I could go into a whole like nerd like a dissertation here about like how the goal isn't to write papers, right? Like we get trained to think that like that the goal is to write papers, but the goal is to do work, right? Like the goal is to be on podcasts and talking to people about like what your work is meaning, rather than like publishing papers. And then the papers will fall from all the stuff that you should be doing anyway, but that's neither here nor there. If the question's about where to access, like where we would put like data that we're operating from, the answer to that, either fortunately or unfortunately, is that like we keep that secure, right? So like really anybody could engage in similar public access requests that what we've done, but the ways that our protocols work and under the institutional review board requirements that we have at the University of Colorado, we collect this data, we keep it on, you know, encrypted, password protected servers that are all within buildings that have at least 3 levels of locks on the outside of them. We protect that data in the same way that we protect health data. So yeah.
Challenge accepted. We'll see how encrypted
Mission
it
Impossible.
is.
Yeah, there you go. It's, Edgar is Mission Impossible right now.
So what is the reason for protecting the data? Because like obviously you're sharing some of the findings publicly, but it sounds like you're very protective of the hard data. Is there a state mandate there? Is there just a personal PII mandate? You know, like what's going on with that?
Yeah, I think it's a really good question, and I think like that my general approach is to like, whether I got that data from publicly available records or whether it was because I knew who to ask and I gave them a survey or I did an interview with them and we had that transcript, or if I treated them clinically and then I had notes about them, I'm going to protect that information in exactly the same way. Like I'm going to use the same protocols to do that. Now, when I talk on here, right, I'm talking in generalities, right? Like
Mm-hmm.
I've been very careful, even in the cases where I was talking about a specific case, to like not give you anything that you could use to track it down to a specific circumstance, right? And so I think that's both the ethical and the responsible approach when you're dealing with anything, obviously like HIPAA protected or whatever, but sensitive, obviously, otherwise.
Okay. And then knowing that public information can be helpful if it's good information, does FIPI have a plan for putting together publicly consumable data around ERPOs?
Yeah. We have a couple of things, right? So one of the things that is out there that we have contributed to is the Colorado firearm violence dashboard, and I know that like that's not the title that everybody would necessarily prefer, but if you Google that, it's on the website of the Office of Gun Violence Prevention. We have a dashboard that like needs to be updated every so often, but it gives you an idea of of a variety of firearm injury related topics, including ERPOs and where they're being petitioned for and where they're being granted. We also have some more general, just sort of educational information in some one-page documents, and I didn't bring those, so I apologize for that. But like the fundamentally, I think what we would want.
Nice job,
That
Edgar.
was perfect. When I heard it at first, I thought it was going to be the losing sound from The Price is Right, and it was even more pointed than that. But we have some good information about like just who are eligible petitioners, how do they work, what are the due process protections that are in place, how long do they last for, things like that, and then what are the proportions of ones that are filed by what petitioners and alleging what kinds of threats and stuff like that, like things that are just points of fact, not taking a position one way or the other.
Well, I've reached the my time limit for this evening. Is if you guys want to continue talking, you're more than welcome. But I'm going to have to jump off. But I just want to say thank you very much for coming on and talking to us, answering our questions, and not taking anything personally, at least not outwardly.
No, I appreciate your time and appreciate the opportunity to be on here. I know that like people disagree, and that's the entire point of this. But it's like having conversations like this that actually can make a difference, rather than getting into some like battle over who's right.
Yeah. I think just in the interest of consistent conversation, I think we'll call it good. If anything, we make part 2, if it's appropriate for all you guys, because this is a lot of fucking information. A lot of information. We've been at it for almost 2 hours. So if you guys are good with it, if you're at a time crunch, just to keep things consistent and good, I think we'll call it good for today.
I'll follow your lead.
Yeah, but for sure, appreciate you making time. The Constitution, I would argue that it's not right because it allowed people to interpret it in ways that we didn't want it to be interpreted. So I would say
But on that note, I will say thank you to Joseph and
Correct.
Tisha and Rob and a couple other people who did provide comments and questions. And as usual, we, even if we don't agree, we want to hear everything that comes up in your head when it comes to this stuff, because we need to know what people care about, and we need to know what people know and don't know. So,
yeah. So appreciate it, Chris. I appreciate everybody in the comments. Thanks for doing this. We'll see you in 2-ish weeks.
Yeah.
Awesome.
Yay.
Yay.